Social Media's Contribution to Court Cases by Callie
and Penelope. Our research question was, how can social media influence the results in court cases, and how can it be applied in different areas of Canadian law?
There are approximately 31.76 million social media users in Canada, and I'm assuming that the majority of students at Rockridge have an online account. So many people use it daily to communicate, share their lives, and exchange information. Knowing and acknowledging that social media is harmful under the right circumstances is something that everyone should know. A simple comment or post can impact someone's life greatly. Just because it's not online doesn't mean there are no consequences. As the attorney Sherwin Arzani said, you should remember that social media is evidence and discoverable. Depending on the situation, your opinions can either hurt or help your court case. Therefore, the significance to Canadians is that many people know this but don't apply it to their lives. Social media has the ability to entirely change the outcome of a court case.
When it comes to identifying someone allegedly involved in a crime, there can be risks associated with seeing photos of people on social media, as the recent case involving convicted killer Adrian Bailey highlights. Bailey was arrested in 2012 for the murder of Jill Mager. In 2013, he was sentenced to a minimum term of 35 years. In 2014 and 2015, Bailey was found guilty of sexually assaulting 3 other women. The first incident was alleged to have taken place in 2000, and the other 2 were in 2012, only months before he killed Mager. As a result of these new convictions, his sentence was extended so he was ineligible for parole until 2058. Recently, the Victorian Court of Appeals overturned one of Bailey's new convictions and cut his minimum sentence by 3 years. This is because the victim of the attack in 2000, identified as GH to protect her identity, initially identified Bailey during the social media storm surrounding Mager's death. In 12 years after her attack, she was on Facebook and saw a missing persons page for Mager when, according to her evidence, she knew for certain Bailey was her attacker. At trial, the jury accepted GH's evidence and convicted Bailey. He then appealed to the Court of Appeal, arguing that no reasonable jury could have found him guilty beyond reasonable doubt. His argument was that the initial circumstances of the victim identifying via Facebook were too unreliable, and that the later ID by police was therefore unreliable as well. The appeal of court agreed, saying there was too great a risk that her ID was tainted by the phenomenon known as the displacement effect. This effect is one of the ways in which post-event information can change how we remember an event happening. Our brains subconsciously tricking our memories. The displacement effect more specifically involves visual misinformation, seeing the person after the event in a photo, video, or real life, and then linking them to the event for some reason, and then falsely remembering them as having been involved. The streams of photos posted of Bailey gave GH an entirely new way to identify who committed the crime. However, it made the evidence unstable and potentially unusable in the process. Prior to social media becoming such a daily part of our lives, the displacement effect wasn't a huge problem. We didn't have access to mass databases of photographs of people we may or may not know. But that's all changed through social media. We now have access to photos of friends of friends, as well as photos of strangers. There are exponentially more opportunities for our brains to go on their amateur investigation and try to find the culprit. This means that eyewitness identifications might even be more unreliable than ever, already accounting for more than 2/3 of wrongful convictions in the United States alone. Courts need to be extra careful to scrutinize the circumstances in which someone has identified an accused. If the initial identification took place under suggestive circumstances, such as a witness searching through Instagram in the hopes of identifying the offender, their identification may not reach the standard needed to be used as evidence. The circumstances in which the displacement effect will pose a particularly dangerous risk are when we actively try to find the person. Your brain will fill in the gaps whether you want it to or not, and this could stop a case from being beyond reasonable doubt.
During and before the litigation process, counsels can use social media to prove mens rea, quicken the process, and other aspects of their cases. Further, it can speed up the discovery process accordingly. Each page of social media account can be used for the purpose of discovery, and if relevant, can be listed in a party's affidavit of documents, though just the existence of social media account is not sufficient. Some issues that arise from using social media include obtaining the documents from opposing parties, but also the defendant complying with the usage. An issue can also arise when the account is private, yet even though you have posted things privately, your account is not immune to being used as evidence. If the online information is important enough, the general disclosure requirement allows likely relevant social media to be used in litigation, whether or not the profile is private or public. To get this information, Norwich Orders are used. A Norwich Order is a pre-discovery production from third parties. This allows a counsel to use evidence to disclose information that can be used to identify anonymous comments. And finally, some evidence is completely admissible, giving it the name best evidence to prove cases. A few examples of social media being used as evidence in different trial types includes Bagabas v. Atwell, where personal injury was proven inconsistent. The accuser claimed to have injuries from the defendant's negligence and claimed to no longer be able to kayak, cycle, or hike. The defense counsel was able to prove this wrong by producing photographs posted on the accuser's social media showing he was completely capable. The court had the conclusion that there were no long-lasting injuries. For family cases in Kolodiziki v. Kozanaki, the father failed to attempt to reduce child support because of his online photos using a powerboat, skydiving gear, and motorcycles. Given his comfortable lifestyle, he could afford child support. In criminal law, social media can help prove mens rea. In R.V. Torodovic, the accused's Facebook chats were used as admissible evidence to prove mens rea. Comparatively, during the labor case Lockheed Imports Limited versus United Food and Commercial Workers, the employer was able to use the employee's offensive social media accounts to justify termination after the employee brought them to court for unfair termination. During the Windsor-Essex Catholic District School Board versus Lentini, a parent upset about the school's hockey program changes started Facebook groups to spread information that the principal is a pedophile and engages in sexual relationships with other teachers, along with comparing him to Hitler. The parent was then liable for defamation. Similarly, in R.V. Weavers, the accused posting on MySpace showed substantial allegation of a death threat being used as evidence in the criminal law case.
As Callie has discussed, social media has given us more potential evidence to use in criminal law court cases. Social media can help prove mens rea and help the court come to a conclusion on a case. Social media also gives a platform to keep court cases transparent. A fundamental aspect of the proper administration of justice is open justice. Fair, accurate, and, where possible, immediate reporting of court proceedings forms part of that principle. Another good thing, the use of social media has helped and continues to help find missing persons. If a person goes missing, commands make initial notifications on social media. As that information gets retweeted by the police and the public, word spreads very quickly to be on the lookout for that missing person. Millions of people now know who to look out for and where to contact to bring them back safely. Chances are none of those people would have seen a missing person. Of course, the good always comes with the bad. The use of social media has created the opportunity for new crimes that the courts don't know how to deal with. For example, revenge porn, posting explicit photos without their consent as a form of revenge. Social media has also made it easier for criminals to track and stop potential victims. As our use of technology quickly expands, the legal system has to make changes to keep up.
More research that we could have added was what laws govern a social media user, how social media businesses' policies impact certain things, or a few more contrasting court cases that involved social media as well. Yet other people can still use our research while possibly being a part of a court case. The earlier you know this information, the less likely it is that your future self will be wishing you never commented or posted that information. Since social media is such a huge influence in modern day, it is important to think of the future and other online users. Research shows that people are often a lot less respectful and polite than in person, mainly because you're hiding behind a screen. Applying knowledge that any anonymous comment or message you've typed out online can be used against you under the right circumstances if you possibly have a future court case. From this, be careful what you post and do online. We're excited and thank you!